Truth is the lifeblood of a legitimate criminal legal system. Without truth honestly reported, faithfully preserved, and transparently presented, justice becomes not just elusive, but impossible. Part 2 of this book examines the structural and functional role that truth plays across the entire criminal process. From arrest to adjudication, every phase of the system relies on a foundational presumption that the information law enforcement officers provide is accurate, complete, and untainted by dishonesty or omission. The obligation of truth in the criminal legal system is not an abstract ideal. It is the operating assumption upon which police investigations are initiated, charges are filed, plea bargains are negotiated, and verdicts are reached. Officers, by virtue of their power to investigate, arrest, and testify, act as gatekeepers of the system. Their words, their reports, and their conduct set in motion the legal consequences that follow. When that input is corrupted through deliberate falsehoods, strategic omissions, or reckless misrepresentations, the system itself becomes distorted. The fragility of a truth-dependent system. The criminal legal system's dependence on officer truthfulness is unique. In no other institution do mere words carry such enormous weight. An officer's sworn statement can lead to the denial of a person's liberty. A narrative in a police report can determine whether a case proceeds to trial. A single piece of unchallenged testimony can tip the balance between conviction and acquittal. This disproportionate reliance creates a fragility. If the input is false or misleading, the consequences are profound. The structure of criminal procedure magnifies this fragility. Much of what happens in the justice system occurs outside public view at the level of pretrial hearings, behind closed prosecutorial meetings, or through plea negotiations where the defense may never see all the facts. In such a setting, truth must be treated not only as a virtue, but as a safeguard. Without it, the unseen machinery of justice can produce outcomes that are not merely unfair, but deeply unjust. The officer as a primary source of legal truth. Officers are not neutral observers in the criminal process. They are often the first narrators of the official story. From the moment a crime is reported or discovered, officers begin shaping the evidentiary landscape. Their field notes, arrest affidavits, incident reports, and forensic interpretations form the core of the state's case. Prosecutors build upon these foundations. Judges issue warrants in reliance on their declarations. Juries evaluate the credibility of officers as central to determining guilt. This centrality places an extraordinary ethical and legal burden on the officer. Unlike civilian witnesses, whose biases or lapses might be expected, officers are trained, empowered, and presumed to be both competent and truthful. Their testimony carries institutional authority. That is precisely why a lie told by an officer is not just an ethical violation, it is a systemic betrayal. It calls into question the fairness of the case and the integrity of the institution. The compounding effect of dishonesty. The damage caused by dishonesty in the legal system is rarely isolated to one case. When officers lie, fabricate, or conceal material evidence, the harm compounds. First, it affects the accused, who may suffer incarceration, reputational harm, or loss of employment due to a flawed process. Second, it misleads prosecutors and judges, who rely on law enforcement for accurate information to make lawful decisions. Third, it misinforms the public, particularly in high-profile cases, undermining societal trust in the system's legitimacy. Perhaps more insidiously, such dishonesty becomes precedent. It establishes an internal culture where bending the truth becomes a means to an end, whether to secure convictions, protect colleagues, or maintain departmental reputations. When unchecked, this culture metastasizes, creating patterns of misconduct that spread throughout departments and jurisdictions. Scandals such as the Rampart Division in Los Angeles or the Gun Trace Task Force in Baltimore did not arise from isolated misdeeds. They were the product of tolerated dishonesty and systemic silence. Prosecutors' dependence on police integrity. The prosecutorial arm of the justice system is wholly reliant on the integrity of its law enforcement counterparts. Prosecutors do not investigate crimes directly. They review the work of investigators, decide whether charges are warranted, and advocate for the state at trial. At every stage, the prosecutor's decisions are only as sound as the information provided. When officers present incomplete or false information, prosecutors risk making charging decisions based on fiction. This risk is magnified in plea bargaining, which now accounts for over 95% of criminal convictions in the United States. Defendants often agree to plea deals without seeing the full breadth of evidence against them. If the discovery process is polluted by suppression, misstatements, or failure to disclose material facts, the plea is not truly informed and justice is not truly served. Prosecutors also risk personal and professional consequences when relying on untrustworthy officers. In recent years, courts have overturned convictions based on post-conviction revelations of police misconduct. In such instances, not only is the conviction invalidated, but the prosecutor's office may face ethical scrutiny, civil suits, and reputational damage. Increasingly forward-thinking prosecutors are developing Brady/Giglio disclosure units and internal policies to identify problematic officers before they undermine prosecutions. The defenses struggle without full truth. No party in the criminal system is more dependent on the truth than the defense. Defense attorneys must respond to allegations often constructed entirely by state actors, officers, and prosecutors. When material facts are withheld, altered, or fabricated, the defense is forced to litigate in the dark. Even well-funded defense teams struggle to compensate for lies embedded in arrest reports or inconsistencies buried in redacted records. This power imbalance is especially acute in public defense, where resource constraints already limit investigative capabilities. If officers withhold exculpatory evidence, conceal impeachment material, or testify untruthfully, the defense may never uncover the truth, particularly if the court assumes the officer is credible. The presumption of officer honesty, when unearned, becomes a barrier to justice. Recent cases have shown that wrongful convictions often trace back to dishonest or incomplete information provided by police. Organizations such as the Innocence Project have uncovered hundreds of exonerations rooted in misconduct or suppression of evidence by law enforcement. These cases are not anomalies, they are warning signs that truth in policing is not just an ethical standard, but a procedural requirement. When truth fails, the legal system convicts the innocent, shields the guilty, and loses the confidence of the public it claims to serve. Public trust as a legal variable. The role of truth in the criminal legal system is not confined to the courtroom. It reverberates into public consciousness and civic life. Each revelation of officer dishonesty, whether in an internal investigation, a media exposé, or a judicial opinion, chips away at the perception of justice. Communities most affected by aggressive policing and prosecutorial overreach already carry deep skepticism about law enforcement credibility. When these suspicions are confirmed by evidence of dishonesty, they harden into distrust. That distrust is not benign. It affects jury pools, community cooperation with investigations, and the ability of prosecutors to secure convictions. It feeds into political discourse about the legitimacy of the system and fuels movements for reform and accountability. In this sense, truthfulness is not only a legal variable, it is a societal one. A system that cannot guarantee truth in its most basic functions loses not just cases, but its claim to moral authority. Toward a culture of truth. For the criminal legal system to function with integrity, the culture of policing must evolve from one of insular loyalty to one of public accountability. Officers must be trained not only in tactical skills, but in the ethical imperative of truthfulness. Supervisors must be equipped and empowered to discipline dishonesty swiftly and transparently. Prosecutors must rigorously screen the credibility of their law enforcement witnesses, and defense attorneys must be given the tools to uncover hidden facts. Technology can help body cameras, digital records, and public databases increase the visibility of officer conduct. But no tool can replace institutional commitment. Truth cannot be an optional virtue. It must be a non-negotiable foundation, legally required, ethically demanded, and systematically reinforced. I am a dedicated author and researcher specializing in the intricate nexus of technology, law, and government. My extensive body of work includes a diverse array of books, scholarly articles, and policy papers that delve into the evolving challenges and opportunities presented by technological advancements within legal and governmental contexts. Through rigorous analysis and insightful exploration, I examine how emerging technologies such as artificial intelligence, cybersecurity, data privacy, and blockchain shape and are shaped by legislative frameworks, regulatory practices, and public policy initiatives. My publications aim to bridge the gap between technical innovation and legal governance, providing comprehensive resources for policymakers, legal professionals, technologists, and academics alike. By addressing critical issues like digital rights, cyber law, technology-driven governance, and the ethical implications of technological integration, my work contributes to the development of informed and adaptive legal systems capable of responding to rapid technological change. I am committed to fostering a deeper understanding of how technology influences governmental operations and legal standards, and vice versa, thereby promoting the creation of robust, equitable, and forward-thinking policies. In addition to my writing, I actively engage with government agencies, legal institutions, and technology firms to offer expertise and collaborate on initiatives that ensure the responsible and effective implementation of technology in public spheres. My dedication to exploring and elucidating the intersections of technology, law, and government underscores my commitment to advancing knowledge and facilitating informed decision-making in an increasingly digitalized world.